This hearing is in the matter of case number CFI 030-2022 and is being held by way of video conference before Justice Sir Jeremy Cooke, appearing from the UK. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Norton Rose Fulbright. Lead counsel is Mr. Tom Montague Smith, KC. The first defendant is Axel Maines and is representing himself. The receiver is represented by Clyde & Co. and the lead counsel is William Prasivka. The third party is represented by Iptelix. Lead counsel is Mr. Cesar Ghalib. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
Confirmed, thank you.
Confirmed.
Yes, confirmed, the receiver.
Confirmed for the claimant. Thank you.
Confirmed.
Yes,
for
that's
the
correct.
applicant.
Thank you all.
All right. Mr. Montague Smith, as you're the claimant, you probably better open.
Thank you. Yes. My Lord, firstly, apologies for my delay in attending the hearing. For some reason my link wasn't working, so I do apologise for that. But we're here now. Your Lordship's aware of the background to this claim, so I'm not going to get into that in any real detail. I'm sure you've read the skeleton arguments, if one can call them skeleton arguments. We've had something rather more extensive from the bank, arrived 2 days ago, and I'll get into that in a moment. But your Lordship's aware that you have 3 applications before you today. Can I just ask Mr. Khaled, please, to mute his line, because it's giving us feedback. Thank you very much. Thank you. Appreciate that. You've got 3 applications from the parties. And from our perspective, the claimant's perspective, the central issue is this one of whether or not the proceeds of sale of the restaurant can be distributed. So that's really the core of the issue. And it runs through all of the applications. It's the basis of the bank's joinder application, and obviously it's central to my application, which is for the release of the monies. So I was going to deal with that issue first, if I may, and then circle back to deal with the other 2, if that's suitable for your Lordship. And we say this, that the starting point is that Five Dining, the company, has realised a profit from the sale of the restaurant. And that profit is the subject of a proposed distribution. Now, ordinarily, the court would not intervene into a company's decision to make a distribution. And you would expect that someone who makes some sort of objection to that, explains that there's some sort of legal impediment to that distribution, would be able to tell you in terms, what are the facts, here, show you the evidence, and give you the legal analysis to explain why that distribution cannot be made. Now, what we have is an objection from the bank presented in what was originally a 5-page skeleton argument, which was supported by 10 exhibits, and there was a 5-page affidavit from Ms. Sava, you may have seen that, which had another 10 exhibits, and then 2 days ago we got a 32-page skeleton argument, which when you actually up the font and spacing to regulations, probably more like 45 pages. So we've got about 50-odd pages of submission and affidavit from the bank, and attached to that was another 22 documents. So we've had a couple of 100 pages really from the bank. Now, amongst all of that, your Lordship will find not a word about the legal case that the sums should not be distributed. So what the bank says is that it's owed money by Five Dining. It claims that Five Dining has no other assets than this pot of cash that's been realised from the sale of the restaurant. Those are the 2 assertions that it makes, and I'll deal with those. The first claim we say is doubtful as things stand today. At least it hasn't been made out on the evidence. And the second claim is simply flatly wrong. There is a pot of cash sitting in Sokjen, Lebanon, the parent bank of the bank. Now, I'll come back to those allegations, but just what do those allegations, where do they get the bank?
Yes, Smith, my basic question is, well, you know, unless the company is in liquidation, I just can't see what the issue is.
That's exactly the punchline of this submission, which is that there's not a word of explanation from the bank about how, even if those things were made out, the court should intervene in the proposed distribution of a dividend. You've got a profit that's been realised from trading. It's unusual trading, but normally that there's nothing in the court in the company's law, certainly nothing that anyone's identified that would restrict the distribution of a profit in these circumstances. And so if you take it from the perspective, if this was being done in the boardroom, would the bank be able to restrain somehow the directors issuing some sort of dividend at this point? And the directors' obligations are to the company, not to the creditors. Nobody's suggesting the company's in liquidation. It's not in liquidation. And in those circumstances, it's very difficult to see how anyone can restrain the distribution of these monies as by way of dividend. Is that the point that your lordship was concerned?
My simple mind, that's the beginning and end of it.
Yeah.
Whether you want to address me on whether you say the bank debt is dubious or not is up to you. I couldn't follow the point when I looked at the bank statement, which seemed to be suggested in your skeleton, showed that the $73,000 had in fact been credited, but it didn't look that way to me from the account. It looked as though there was 73,000 outstanding, but namely the September 2022 instalment. If you want to address me on that, you can, but I'm not sure at the end of the day it's going to matter.
Well, we say it doesn't matter, but just in case there is this goes any further, I suppose I might just try and help you with those two issues. One is there a debt currently? And then the other is, are there any other assets out there which could be if you're not
plainly assets out there, the asset at the Lebanon Bank. There may be an issue about accessibility, but on the evidence, I can't say that there is. It's plainly disputed. So that the only point I would like help on, if it matters, is why you say that there's some doubt actually that the debt is owing.
Yes. So
there are 2 points that arise in relation to the debt owing to the bank, as I see it. One is whether or not the September 2022 instalment was paid or not.
Yes.
And the second is whether, as a matter of the law of Cyprus, which governs the loan agreement, and about which I'm not clear that I have any direct evidence of Cyprus law, as to whether or not, if that amount was unpaid, there is indeed an entitlement to call the loan in, whether as a result of what we think of as contractual acceleration, or whether as a matter of Cypriot law you can terminate and then ask for all the money back.
Yes.
And I'm a bit short on Cyprus law and evidence, I think.
I agree with that exactly, and I think we've approached it simply on the terms of the agreement, and we say it's not a sort of recognisable acceleration clause that we can see. It's on page 98. It's recited in Ms. Saba's affidavit, top right of the page, and I've just got a couple of observations I'd make on that. What it says is, failure by the borrower to proceed with paying the amount due shall give the bank the right to demand through legal proceedings or otherwise the payment of such debts plus interest. So it's the amount which is due, that's the interest, because obviously it's a failure to pay the amount due, which is being addressed here. The only amount due prior to the full term of the agreement is the interest. And then it says it gives the bank the right to demand through legal proceedings or otherwise the payment of such debts. Those could only be the amounts due.
Yeah,
and then
it's the last sentence, isn't it, that
it is,
gives rise to a potential issue.
It's at least ambiguous because it says failure by the borrower to pay the above immediately. Yeah. That must again mean the interest. Shall result in the charge of default interest from the date of demand, and so on. And then it says, furthermore, the bank shall be entitled by terminating the agreement to initiate legal proceedings or otherwise demand repayment of the debt, plus any court and other expenses. Now, the ambiguity arises from this sort of reference to termination, but the debt has been throughout that clause identified as being the amount due. And so what we would read that clause as saying is that ultimately it's entitling the bank to bring whatever actions it needs to bring for the debt, for the interest that's due. Now, I accept there might be an argument of one way or another, and there is reference to termination, but it is far from clear, and we would say that the company would have at least an argument that it could say, well, you know, all you're entitled to do at that stage is bring proceedings for the sums that are due. There's no classic acceleration clause. It's not a straightforward one, and it's on not standard terms, but certainly in the context of a bank customer relationship, one would expect a court to say if acceleration is what you're looking for, that is what you should say. Now, the interest, there's two other points. It's not just has the payment been made, it's if it hasn't been paid, why has it not been paid? In relation to has it been paid, the document that we alighted on was page 228 of the bundle. And it's very unclear.
Well, bear with me, I'm just getting it up.
Of course.
Yeah, this is what I was looking at.
Yeah, so the total loan amount was 4.6 million, 4,607,100. So you see that at the top.
Yes.
But you also see it at the bottom right. That's the amount that's due. So what you have is then a series of entries, and you'll see about 4 entries down, 29 September 21, interest payment, and then that's 73,713. And then underneath that, 30 September 21 is the interest itself. So you've got the prepayment of the 73,000 interest, and then the interest arises, and you end up with the net debt on the right hand side, which matches the actual principal amount. So in other words, interest is paid in advance one day, accrues, those are netted off, and you get back to the debt. And then the next two lines are the ones that we were identifying as being relevant, because, and these are the bottom two lines. Again, you've got 29 September 2022 interest payment, 73,713. And then the following day, you've got the interest is incurred and then netted off, and you get back to the principal amount. So we looked at that. And as far as we can tell from that document, the interest has been paid. Or at least on the face of the evidence, that's what's going on. Now, what you've got against that is you've got two things. You've got Ms. Sava in her affidavit just asserting that there is a default, but she's a lawyer and she does not give the source of her information. It's of no use whatsoever. And then we've got a series of assertions in the skeleton argument about this, which have no evidential value at all. So we say there is a real doubt, and I don't think we would say you cannot decide today, but there is a debt that's outstanding, if that matters, which I appreciate your lordship's point. The other point, though, the third point in relation to this is that you will have seen that the bank has been extremely coy about this Lebanese deposit, and extremely coy about its relationship with SocGen Lebanon. They pretty much say, well, we are separate legal entities. As far as we can see, SocGen Lebanon is the parent of SocGen Cyprus. And according to Mr. Manes, the interest due on the loan was repaid from interest accrued on the Lebanese deposit. He says that at page 116 in paragraph 10 of his statement. And so,
sorry, reference again.
Page 116, paragraph 10. He says that the interest was serviced.
Yes.
it's about
Yeah.
6 lines down. He says the intentional position of SocGen Cyprus and SocGen Lebanon to have not simply transferred the funds for the yearly interest as they have done previously, or to simply execute a bank transfer of the cash. So he's saying that what has happened in the past is that this fund has been ring fenced. It's generating interest at the same rate as the loan, and all that's supposed to happen is the interest is to be taken from the deposit applied to repay the loan, and that has happened in the past. So that raises the question, why has it not happened now? The obvious answer, one might infer, but you don't need to go that far, but we would suggest is that there is some arrangement for that to be the case. But at the moment, you don't know anything about any of that.
Is it right that even amongst the 222 pages or so that are attached to the skeleton argument from the bank, we still don't have a copy of the loan agreement? I haven't been through all that yet.
And it's not been produced. I think there might be a loan agreement. I think the loan agreement is somewhere in the papers, and I can dig it out for you. Oh, I think it is. It's bundle F1 actually. It is there, but it wasn't produced by the bank. It was in there though from a previous affidavit.
Yes, it was referred to as being enclosed with an email at some point.
I think it is in the bundle. It's at document F1. It starts at page 125. So you do have it.
But there's no argument about the relevant term that is relied on. That's the only term that's relied on, is it?
Correct. It's been reproduced in the affidavit. It's the same term. So that's the first issue. The first issue is there an actual debt? And we say, well, A, it doesn't look like there's any debt, and B, if there is, it could well just be 73,000, and C, if there is more than that, then one would want to understand, for the purposes of a distribution, why that debt has arisen, and is it as a result of some arrangement? Because if as we have said, Mr. Manus has explained that and has given instructions that deposit should be available. Then, and if the bank has arranged simply just not to accept that deposit or agreed that it won't be paid, then we would say that one way or another they're not going to get their money. So that's the first bit. And the second bit is then the value of the deposit itself. And the obvious thing, the answer is, look, even if prejudice was the issue, they can just get that money from their parent. And there's all these English authorities, which we've identified in our skeleton argument, which explain that what the bank says is just something that everybody knows, which is that there are difficulties of getting foreign deposits out of Lebanese banks, is actually the result of the restrictions the banks themselves have imposed. There's no legal basis for those problems. They are practical issues, if they exist in this case, and they're imposed by the bank themselves. And so in the Manukian case, for example, we've identified the passages in our skeleton, but in the Manukian case, the problem was that SocGen Lebanon was just refusing to issue deposits, and that it was the result of a blanket directive from within the bank to employees just not to honour transfer requests. So so in all of those cases, the English courts granted specific performance of the obligation to comply with, and those are the two Bitar cases and the Manukian case. And in those cases, the bank didn't show up and just say to the English court, well, everybody knows that Lebanese deposits are worthless. But that is all that the bank has done in this case. It's all contained in paragraph 109 of the bank's skeleton argument. And it's a stream of consciousness about why everybody knows Lebanese deposits are worthless. In fact, if there is a problem, which hasn't been evidenced, it's a practical one. And what that means is that the relationship between SocGen Cyprus and SocGen Lebanon becomes extremely important. Because what the bank would then be asking you to accept is that SocGen Lebanon would not comply with a concerted request by SocGen Cyprus to make the transfer. And in fact, we call it a transfer, but it's more likely to just be a book entry between the two entities. And in light of the fact that the deposit has been used to service the interest in the past, long after these problems arose in Lebanon, given the relationship between SocGen Cyprus and SocGen Lebanon, we would say you simply cannot accept that assertion. And in fact, it's deeply improbable. But at the least, you'd expect to see some correspondence between the banks on it. So even if this went anywhere, we say they just haven't made out the factual propositions that they rely on in support of their position. So those are the two, well, really the three short points that we make. Their case relies on them having a debt. We say they haven't made that out. Their case relies on there being no other asset than this pot of cash. We say they haven't made that out. Their case really should articulate some legal basis on which, even if those two things were true, this court could say, well, you can't distribute this cash. And you've got nothing really on that final point, and not enough on the first two. So, my lord, those are really the sort of central submissions that we make on what we say is the most important issue for today. After that, really, everything is sort of neither here nor there from our perspective, in the sense that on the joinder application from the bank, I mean, they make their application under Part 20. We say it's wholly misconceived. What we'd understood was that they were going to try to piggyback their claim against Five Dining onto these proceedings, but now we know that isn't true, because they've started separate proceedings against Five Dining, and that was one of the documents attached to their skeleton argument. In their skeleton argument, the bank says they started those proceedings on the 28th of September of this year. That is not actually true. They started the proceedings on the 3rd of October.
But can you just direct me to where the claim form is?
I've gone slightly out of order, but it is, I think. Yeah, my apologies. You just have to find it.
Okay, so it's page 1443, if that helps.
I'm sorry, 1443.
Yeah.
Thank you very much. I should have that to my hand, but I don't. So they've started the debt claim against the bank and against Five Dining and against Mr. Manus under the terms of this. I mean, part of what we say about all of this is that even if there was evidence to support what was being asserted, even if it led to some sort of gave rise to some discretion or some balancing exercise, we say what has happened here is deeply unsatisfactory, because the bank has essentially sat on its hands since September last year, when it says that the debt arose, the default arose, and it's issued proceedings, you can see, simply on the 3rd of October, 2 days before the hearing, in which we are asking for this money to be released. So they've sat back and watched as the claimant has spent, frankly, millions of dollars pursuing a claim, trying to realize this money to satisfy a debt that's existed for years now, and done nothing about it. Now, they say they couldn't have done anything about it because they didn't terminate the agreement until July. So that's the beginning of the date. But they could have terminated before then. It was always in their gift. They say, well, under Cyprus regulations, they have to give a certain amount of time, but they certainly don't need to give 9 months. They don't need to give a year. And so they could have done all this sooner. I mean, the other thing they say, if you look at their skeleton argument, my lord, at paragraph 71.
Yeah.
They say it's on that basis they lodged the claim on the 28th of September. They didn't. They did it on the 3rd of October. And they say, and could not do it prior to that, brackets, given the time required to compile and prepare the claim for submission, between the termination date of 14 July and the submission of the claim before the DIFC courts on September 28th. So there's a factual assertion there made by lawyers, endorsed by the bank, that it took them over a month to draft that 2-page claim form that you've seen. I mean, that's what you're dealing with. You're dealing with that sort of factual assertion. So we say it can't be right, even if you get some sort of discretionary question, it can't be right that they should be able to just reap the benefits of a very expensive receivership process and the trial that came before it that has resulted in this cash being put out. But you just don't get there in the first instance because nobody's explained the legal basis on which these distributions can be restrained. So, my Lord, we produced with the skeleton argument a revised draft order. The intention of that was to seek to combine together the proposals that we had made and the proposals by the receiver, which had been accepted by the receiver. It's not an agreed draft order by anyone. The receiver takes a neutral position in relation to the distribution, doesn't seek costs and so forth. But I can take you through the order either now or in due course once you've heard from bank and indeed from the receiver, whichever order you would prefer.
Well, I think it's best to hear from the other parties first.
Very good. Thank you.
Mr. Pasipka, do you want to say anything very specific at this stage or not?
Well, no, Judge. I mean, very concise submissions, less than 10 minutes. I'm not sure what you should hear from me now. I mean, the thrust of our submission is that we're taking a neutral position.
Yes, well, I've read your skeleton, so I don't think I need to hear from you, at least at this stage. And no objection is being taken to your increase in fees by the claimant. So,
Yes,
probably I don't need to hear from you now. And
the only issue, obviously, certain allegations made against the receiver, and my client would be eager to set the record straight. But obviously, we're in the court's hands. If the court would like to hear from us on that.
I'll give you a chance to say something if I need to hear from you on that score. All right. Can I hear then from Mr. Khalif for the bank, please?
Yes, Your Honor, thank you. I would first like to start by addressing the issue of the lengthy skeleton of argument and deal with this small housekeeping matter before I address the comments introduced by the claimant's counsel. And I'd like to apologize to you, Your Honor, and to my colleagues who have been extremely cooperative in the events leading up to this hearing for the lengthy skeleton of argument. However, we have sufficient reasons for the submission of a lengthy skeleton of argument that I will just address briefly in order not to waste your lordship's time. We have no intention and never had any intention to waste anyone's time or encumber the proceedings or the parties or your lordship. All that we seek in these proceedings and the application submitted is a preservation of the applicant's right. Now, I'd like to note the following. The initial skeleton of argument that we submitted, and as clearly highlighted by the claimant's counsel, was quite brief and supported by a number of documents, limited number of documents. And it was pretty straightforward, starting with the loan agreement, that is the main document in dispute at this stage. However, in all the submissions that the parties have submitted in response to the applicant's application, the applicant was accused of omitting key facts and not providing sufficient elements on the background, including the relationship with the Lebanese bank and the background leading up to the loan agreement. Had those elements and accusations not have arisen in the submissions by the parties, we would not have felt the need to address that and present a detailed skeleton of argument that spans over 10 pages initially, just addressing the background. So if you look at the initial 10 pages, it's just dealing with the factual background leading up to the loan agreement. Those 10 pages are not contested. But because of the accusations made that the bank is trying to advance a particular agenda or trying to omit certain facts, we had to provide this whole factual background for everyone's attention, just to clarify at the same time that this whole factual background is irrelevant. The story starts with the loan agreement that is the main document in dispute, and that is a document signed between the company, Five Dining, and the applicant. So because of that, we had to address those factual backgrounds and submit, a detailed skeleton of argument to address all of those issues. In addition, with regards to the practice direction, it allows for 25 pages and heavy applications that are defined as applications requiring over 2 hours of hearings. And with this hearing scheduled for 3 hours and the complexity of the legal matters introduced in the application and the matters in dispute now involving the foreign bank and the whole background, everyone's trying to poke holes in this application to show that there's actually more to the story than the loan agreement. We had to address all of those things and provide the proper clarification on those matters. So the actual page limit is 25 pages, 10 pages of factual background that we had to introduce due to all the accusations thrown at the applicant, and this being a heavy application. Plus, we had requested originally for the hearing to be a full-day hearing because we believe that there are complex issues that needed to be determined to preserve the applicant's rights and the current proceedings and the events that unfolded in the current proceedings. But eventually, it was determined that the hearing will be listed for 3 hours, therefore, to deal with three separate applications. So therefore, we felt the need to detail the skeleton of argument, just in case we don't have enough time to address all of those matters during the hearing. So for all these matters, we apologize again for the lengthy skeleton of argument, but we believe it was justified given the circumstances. And on that basis, we would appreciate your forgiveness on that and your acceptance of its submission despite the length.
Paul, Mr. Hardev. So there we are. Yeah.
So with regards to the joinder application and the comments raised by the claimant's counsel, I would like to clarify with regards to the statements of account that we just went through. So if you go back to page 228 of the bundle,
yes,
we can see that the claimant's counsel is saying that the interest payment was actually paid on the 30th of September 2022, and therefore there is no default. However, if you look at page 227, because we need to clarify here that there are two separate accounts, right? There's the interest statement of account and there's the principal loan statement of account.
yes.
What happens is when there's a payment that is due, it's debited from the interest payment, from the interest statement of account. So this results in a negative balance in the interest statement of account. But that negative balance is actually debited from the interest statement of account and credited in the loan account. This is why it's reflected as a payment in the actual principal loan account. But you can look at page 227 for the interest, and you can see that there's a negative balance for 73,000 euros for an unpaid installment. So the
that was what I was referring to, Mr. Montague-Smith. It's the balance at the bottom that shows the 73,000
as a negative balance.
But it's the figure at the very bottom that you're referring to, isn't it?
Yes, exactly. So this is the balance on the statement on the interest statement of account that shows a negative balance, and then that negative balance is then credited in the loan statement of account, and this is standard, banking procedures and process. So in reality, there is a default on the loan installment. This is not contested. Anyways, this was also acknowledged by the receivers in his submissions. It was also acknowledged by Axel. The only thing that they disputed is actually whether this payment should have been made from the Lebanese bank or not. The default itself is not contested. Now, everyone's familiar, obviously, with the privity of contracts principle. The loan agreement is signed between Five Dining and Societe Generale Cyprus. The Lebanese bank is not a party to that agreement. When you open a deposit account or open a loan account with the bank, there are contracts that govern this relationship. Now, despite the relationship between the bank in Cyprus and the bank in Lebanon, this has no bearing on the contractual relationship between the bank in Cyprus and Five Dining. The loan agreement was signed between the bank in Cyprus and Five Dining. Due to privity of contracts, this cannot spill over to the bank in Lebanon. To say that the bank in Lebanon or Societe Generale in Cyprus should have recovered that pending installment, outstanding installment from the bank in Lebanon violates privity of contracts and violates the actual agreement signed. I also refer to the transactional protocol, which is page 346 of the bundle. In that document, and this is detailed in the skeleton of argument, so I won't go through that in detail, it's clearly indicated under Article 1 that the relationship is separate. That was following the proceedings that Five Dining introduced in Cyprus, that is against both companies. And I say companies because these are limited liability companies, separate companies with separate legal personality. We cannot say that Societe Generale in Cyprus has direct access to the funds of the bank in Lebanon. Both of them are in different jurisdictions. Both of them are limited liability companies. Both of them are governed by separate banking regulations. So to just say that they have direct access and it's just an entry on the books defies all concepts of banking regulations, privity of contracts, and any legal concept we know. The first installment was indeed paid from the bank in Lebanon, but it was paid based on an instruction from Mr. Mains himself. And this instruction was submitted by Mr. Mains in these proceedings. He issued an instruction to the bank in Lebanon to transfer the first installment amount to his account with Societe Generale Cyprus. So if anything, this supports the argument that in the end, there is no direct link between both banks and there is no direct access for the bank in Cyprus to the deposits, alleged deposits in Lebanon. The transfer was made on instruction from Mr. Mains to his account, to the company's account, actually, instruction on behalf of Five Dining, to Five Dining's account in Cyprus with Societe Generale Bank in Cyprus, in settlement of the loan. For Societe Generale Bank in Cyprus, the second installment was not paid. The company defaulted on that installment. Now, with regards to why Five Dining was unable to make that transfer from Lebanon and the relationship between Five Dining and the bank in Lebanon, we're not trying to, omit facts or play games with anyone. In the end, it's clear that these are separate relationships. The relationship between Five Dining and the bank in Lebanon is private to them, again, under the same principle of privity of contracts. So in other words, the judgments introduced by our colleagues that were issued in England, they actually show that it was clients, depositors, filing claims against those banks in England to try to seek transfer of their funds. It was not anything similar to the situation where an offset was being requested. It was a depositor who had funds in that bank and due to certain reasons could extend the jurisdiction to the English courts to obtain a judgment to have those funds transferred to a jurisdiction outside of Lebanon. It was not a situation where an offset was being requested. So on that basis, there is a default. There is a clear default. Now, I could argue that there is a default on the full loan account. The Claimants Council tried to interpret the loan agreement and the provisions to say that there is lack of clarity in the wording used to suggest that it's actually the full loan amount that would become due in case of default. We have detailed that in the skeleton of the document, and we've already addressed that. It's very clear from the contract that what would be repaid would be the full amount. But that is not the issue. I'm willing to accept that what would be paid is only the amount that was defaulted on, because that would not change the applicant's position and the applicant's entitlement to remedy or the applicant's entitlement to be joined to the current proceedings. So whether we're claiming the 73,000 euros, which have been very clearly clarified as an outstanding amount, or if we're claiming the full amount, this is something between Societe Generale Bank Cyprus and the company and the first defendant in separate proceedings, right? Whatever the amount we're claiming is, this is not the issue of the application. The issue of the application is a joinder application. Whether we have the right to be joined to these proceedings or not. The matter is simple. What is the amount that's outstanding? That is not the issue in question now. At this stage, Your Honor, Your Lordship is only dealing with whether we're entitled to be joined to the proceedings or not. We're not arguing our case, and we're not discussing what relief we might be entitled for. At this stage, we're only dealing with whether there is sufficient reason to join us to the proceedings or not. And based on Article 20.7 of the RDC, in both limbs and the stable jurisprudence and precedents in England and Wales and with the DIFC, it's very clear that it's first desirable to add the applicant to the proceedings because this has been determined by long-standing precedents that if the applicant would be affected by the outcome of the proceedings or by a decision in the proceedings, then they're entitled to be joined to the proceedings. This meets the definition of desirability. With regards to also the first limb, paragraph 1 of 20.7, whether the application would allow the court to resolve the dispute. There's a clear dispute between the applicant and a company whose assets have been sold entirely. And I refer to Article 3.1 of the asset transfer agreement that was submitted by the receiver. It clearly indicates as well that the IP was transferred, not just the assets, intellectual property. So this is a company that was only owning a restaurant under an international name or a global brand with assets. As part of the transfer, the intellectual property was also transferred. This company has nothing and is managing nothing. The receiver himself has indicated that this company will transfer to a management company because it no longer has a restaurant. So its activity with the DIFC authority has changed now because it doesn't have a restaurant to manage anymore, to run anymore. So it's going to be changed to a management company. To say that the proceeds, to try and indicate that those proceeds relate to profits, realized profits that are now being distributed, I mean, this clearly violates companies' law because dividends normally are distributed to shareholders in the companies, not to creditors. The claimant is a creditor here and is seeking remedy through the receivership and the sale of the company's assets. So to try and evade the righteousness and the viability of this application by saying that these are dividends that are being distributed, therefore the applicant has no claim on those dividends, is false and inaccurate. These are not dividends. This is a company whose assets were sold forcefully because there is a claim by the claimant and in remedy to the claimant's claim. They were not sold by the company's management for internal reasons and then distributed as profits. These were forcefully sold to satisfy the claimant's claim. And this will render the company, if the proceeds are released, assetless. Dealing with that assetless issue and the deposits in Lebanon, like I said, there's privity of contract. So the applicant has no direct access to the funds in Lebanon, none whatsoever. And the only payment made from those accounts was upon instruction by the company's manager at the time, Mr. Mays. And the issue of whether there are restrictions in Lebanon is also not a matter in dispute at this stage, because irrespective of that, this is not a condition for the applicant to be entitled to be joined to the proceedings as per Article 20.7 and the long-standing precedents in this matter. So whether, because, and the DIFC judgment that we have highlighted in CFI 044 of the year 2018, if the applicant's remedy, alternative remedy, is complex, lengthy, costly, then in that case, it's desirable to have them joined in those proceedings and save this time and costs. So even irrespective of the availability of that remedy, that doesn't negate the applicant's right to be joined to those proceedings. But again, there is no direct access. And if those funds were easily accessible to anyone, and when I say anyone, I'm representing the bank as a third party at this stage, third party just like the claimant. So if the bank has an easy remedy against those funds in Lebanon, then why did the claimant not pursue that? Why did the claimant, now indicating that they had to go through 3 years of proceedings plus the receivership, if they had clear funds deposited in an account, easily accessible, rather than go through complex receivership proceedings resulting in the sale of a restaurant for a value that does not even cover the claimant's claim? So why hasn't even so, the claimant...
You froze just then. I missed the last
Exactly,
last
yeah, I realized.
minute or two.
So what I was saying is, irrespective of whether those funds were accessible or not, this does not negate the applicant's ability to join the proceedings. And if they were available and easily accessible funds, why hasn't the claimant pursued that remedy? Why has the claimant gone through the alleged lengthy receivership proceedings and costly proceedings to result in a value for the assets that does not even cover the claimant's claim? It's because those funds are not easily accessible, and this will render the company assetless, because again, it's well known, and irrespective of whether it's well known or not, this does not affect the ability to join those proceedings, but it's well known that those funds are not accessible, and the applicant does not have direct access to them as a third party. Now, one more thing that that was raised by the claimant's counsel, and that I would like to address, and apologies for the long speech, is that we've been sitting back watching those proceedings unfold for over a year. Does the claimant's counsel believe that we're happy now trying to engage in those proceedings at the last minute, with the last resort, if rejected, would result in the inability of the applicant to recover its dues? If we had the ability to pursue that for over a year and seek a judgment, obtain that judgment, and maybe join the case as a claimant with a final judgment? It's very clear from the regulations that we submitted that the applicant has to go through a grueling and gruesome process imposed by the central bank in Cyprus. And if the claimant follows the events, because we submitted 5 notices, these were attached to the skeleton of argument, we submitted 5 notices before the 6th one, which was the termination notice. If the claimant follows those events and applies those to the regulations that we submitted, the claimant will see that we did not waste any time whatsoever in pursuing the claim. So we had to wait initially 60 days. We waited 60 days. Upon the 60 days, upon the expiry of the 60 days, we pursued the 2nd notice, 3rd notice, etc. There was no delay between a notice and another. And still, the earliest date we could have achieved the termination was July 2023, 14th of July 2023, when the termination notice was issued to the receiver in his capacity as receiver and manager for the company, and to Mr. Mains. So, and throughout that period between January 2023, when we found out about the receivership, we did communicate with the receiver. We met with him on numerous occasions. So we were not passive, and we were not just taking a back seat waiting for the proceedings to unfold to now try to be joined to those proceedings to partake in the proceeds. That was not the intention at all. But we could not take any action whatsoever prior to July 2023. All that we could do at the time was communicate with the receiver to try and seek and ask him to seek from your lordship an instruction or a direction as to how to deal with the outstanding loan. And the funny thing that I want to highlight is we could have all been spared those lengthy proceedings had the receiver only paid the outstanding interest of 73,000 euros. That was all that was outstanding up until July. If the receiver had taken that action in his capacity as manager of the company, I'm saying not in his capacity as receiver, because in his capacity as manager, he was instructed, or in the mission that we reviewed that your lordship had issued, was to carry on the business of the company. So as a manager, he has a duty to deal with creditors. If there's a creditor that's sending you notices seeking a payment for a defaulted loan, all you had to do was pay that interest or seek direction from the court to pay that interest. We would have all been spared those lengthy proceedings, and actually the applicant would have no claim whatsoever now, because the next installment was due just last month, and it would have been probably too late for us to intervene in the current proceedings. So all that was required at the time was the payment of the installment. That is all that we asked up until July 2023, just the payment of the interest payment of the outstanding interest, and not the full amount. But now we find ourselves in a position where we have to intervene in these proceedings as a last resort, seeing our claim jeopardized, and other parties saying that we took a back seat and did not take any action. So this is not the case. We took every action possible available to us at the time. However, we were bound by policies, banking regulations that prevented us from taking this a step further with regards to the full loan amount. As regards the interest payment, we tried to seek repayment from the company in communication with the receiver. That has not happened. Had the receiver paid that amount, we wouldn't have found ourselves in this position. So to summarize and in brief, all these formalities and background matters are irrelevant, because at this stage we're only dealing with the application for jointer and whether the conditions for that are met or not. For us to argue our case would be the next step. At this stage, all your lordship would do is either approve our jointer application to be joined as parties of proceedings or not. Based on that, based on Article 20.7, based on the two lodestars highlighted in the precedent that we introduced, the Welsh minister's precedent issued in England and Wales, and also the Court of First Instance in case 44/2018 of the DIFC, those conditions are met. If we apply those conditions in this case, the applicant has every right to be joined to those proceedings, because it will be greatly affected by the outcome, because there are disputes between the applicant and parties involved in those proceedings, and because of the imminent harm the applicant will suffer as a result of distribution of the proceeds in favor of the claimant. And one last thing before I conclude. The applicant has at least an equal right as the claimant. The claimant had a claim against the first defendant, who, based on the analysis, turned out to be the beneficial owner of the company, and this served as a backdoor for the claimant to seek receivership over the company. The applicant has a direct claim against the company itself and has a direct contract with the company itself. So the applicant has a higher degree of merit
Direct claim. Yeah.
than the claimant.
I understand. You have a direct claim, whereas their claim is in one sense slightly indirect, because it's against the law.
So to say the least, we are at an equal footing. One thing is for sure, we're not at a lower standing than the claimant. That is for sure. So with that, I'd like to conclude that these were my remarks in terms of addressing what the Claimants Council had raised, and also presenting our point of view on the matter.
Yes, thank you very much indeed. Thank you.
Thank you, Your Honor.
Mr. Pasifka, is there anything you want to say in the light of what has been submitted for the bank? Mr. Pasifka, are you there somewhere?
Sorry, can you hear me, Judge? Judge?
No, I'm having trouble hearing you, I'm afraid. Mr. Halibis, is your microphone off?
Yes, I've muted my microphone.
Thank you.
Sorry, Judge, can you hear me?
That's better. Yes, thank you.
Sorry, Judge. Just one point of fact. The receiver was appointed on the 22nd of December, 2022. That's the date of the receivership order. Now, the purported default on the loan, and I call it purported because we're simply not taking a view on that. The purported default happened in September 2022. So by the time the receiver was appointed, I suppose the event of the court would happen. So I think we would reject the position, why did we not just pay one interest rate? Essentially, the loan was already in default. There were also ongoing proceedings in Cyprus. The receiver's position has always been, it's never been commercial to resolve the dispute between Societe Generale and Five Dining in the context of the receivership. I mean, the receivership order, the receiver had power. The receiver was appointed for the very narrow purpose of realizing value. If it would be helpful, of course, I could take the court briefly through the receiver's relationship with Societe Generale.
How is that going to help me?
Well, it may just give the background, but perhaps it will not help the court. So it will simply give the background to the relationship. I think some allegations have been made against the receiver, essentially that the receiver didn't properly alert Societe Generale or something to that effect. And I mean, my submissions could rebut that, but I don't know if the court would do that.
Well, I think you've told me what you say the receiver's attitude was, that this was a disputed debt which was the subject of proceedings in Cyprus.
Yes.
And
the receiver can't intervene. The receiver does not wish to intervene in this dispute. We really put it no further than that. And just to make one point very clear, it was in fact the receiver, at least the receiver and the first defendant, that alerted Societe Generale about the receiver's appointment. And the receiver has always been in communication with Societe Generale about the ongoing nature of receivership. And I believe the position of the Societe Generale loan was initially brought to the attention of the court on the 19th of January. So this issue has been for quite a while. Reject any suggestion that I suppose the receiver has kept Societe Generale or the court in the dark about this.
Yes, all right. Well, thank you very much, Ms. Praslivka. I don't need to hear anything further from you unless there's anything else you want to say.
No, Judge, thank you.
Mr. Montague-Smith, is there anything additional that you would want to say? I'm not conscious that I need to hear from you on anything specific.
May I just show you one document which might assist on the facts? I don't say that it'll necessarily change your mind on anything, but if we can go to page 334, you see what are, I think, the instructions from Mr. Manes for the payment of interest from the Lebanese account. Now, we heard from Mr. Khaleb that the 2021 interest payment was made from the Lebanese account. He now accepts that pursuant to instructions. We understand this to be the instruction, and you will see paragraph 1.
Page again.
Sorry, 354.
354, sorry.
354.
Bear with me. Yeah.
You'll see paragraph 1. Yeah. The amount of the transfer is to cover 2 interest payments. You got 100. It's not quite, but it's close. It's 143,100. So again, it doesn't shed any light on the question of why that didn't happen. Why it happened in part, if I can put it like that, only for the first transfer, the interest payment, not for the second. But that's
2020 as opposed to either 2021 or 2022.
Well, in 2020, the loan principal is incurred, but the interest is annual, arising in 21 and then 22. Yes. So you've got an instruction to make payment of 143,000 euros, which would cover both those interest payments of 73,000 or close. Do you see? So, in other words, it's not just an instruction to make payment for the 2021 interest instalment. It appears to cover both. But the principled point is that if it is accepted that an instruction from Mr. Manes issued in 2020 was good to cause interest to be paid from the Lebanese account in 2021, then why on earth would it be the case that SocGen Cyprus cannot resort to that account to get its money in due course. This is all post-crisis in Lebanon. And it just, frankly, in my submission, demolishes my learned friend's assertion, which is unevidenced, that everybody knows you can't get money out of Lebanese accounts. But on the facts, that crucial part, really the central allegation, just isn't made out, if it matters. That's all I was going to tell you about, my lord, in response.
All right. Thank you very much. Now, Mr. Manis is actually here representing himself. Is that right, Mr. Manis?
Correct, my lord.
Do you want to say anything?
Yes, I agree completely with Mr. Montague-Smith. The deposit, the instruction that were given in 2020 were at the same position of the situation in Lebanon as now, and this instruction was to pay was to pay the interest of FDC. So everything was done on the same email request by the bank. The bank in Lebanon have done all the bank loan in Cyprus and all this stuff. I never went in Cyprus to make this loan. This loan was done by the Lebanese bank. We have a point when FDC was created, there were no assets in FDC, and we have opened bank account and make all formalities to open a bank account for FDC in both Société Générale at that time. And they asked me to make the full deposit in cash for the subject of this loan. And that's why the subject of the litigation in Cyprus is to compensate the loan by the deposit. This is the essence and the main essence of this litigation in Cyprus. That's why FDC didn't pay the interest in 2022. And that's why nothing from the bank in Cyprus happened before the appointment of the receiver also. Why from September to June to 3 months before July, the bank didn't send a warning letter. They sent a warning letter when the receiver was there. And also I disagree completely with Mr. Galeb, because he said that I acknowledge the default of the loan, which is not true. I never acknowledged the default of the loan, and also why the cash deposit in Société Générale in Lebanon is getting interest every year. The money is there, the money is cash available. The only one who don't want to simply compensate the loan or make a writing in their account is Société Générale, which is managing by the same person in Lebanon and in Cyprus. So thank you, my lord, for your time.
All right, thank you very much. There's nothing else anybody wishes to add at this stage.
Lord, may I just add one simple thing, if I may?
Yes, I'm sorry, who's that? Yes, Mr. Khaled, yes, certainly.
Thank you. I would just like to understand why are we again involving the Lebanese bank, who's not a party to those proceedings, to defend itself, and therefore there is no ability for that bank to defend itself. Therefore, this should not be an issue of the proceedings. And in any case, this is a separate entity. We as the applicants cannot comment on the relationship. So we're lingering on the relationship between Mr. Mains and the Lebanese bank and the instructions and all that. I cannot comment on that. None of the parties can comment on that. And the bank itself is not present to comment on that. The focus is, again, privity of contracts, focused on the loan agreement between the company and the guarantee introduced by Mr. Mains and the bank in Cyprus. The rest is irrelevant at this stage. And again, I draw Mr. May's attention to the transaction protocol. That protocol under Article 1 lists a number of assertions clearly indicating that the companies are two separate companies, that the income for the interest would be paid from direct income of the company and Mr. Mains, and that Mr. Mains acknowledges the absence of any fraudulent maneuvers, etc. So these are disclaimers included in there. And then the loan agreement itself contains a disclaimer at the last page, the last paragraph, indicating that Mr. Mains has had the opportunity to seek legal counsel, etc. So to claim now at this stage that there has been fraud or filed proceedings in Cyprus, etc., all of this, again, is irrelevant to the joinder application, which is pretty straightforward based on Article 20.7 and the existing precedents. And I'd like to highlight that the proceedings in Cyprus, what I understand from the bank's side, have not been progressed. Mr. Mays introduced a measure trying to seek suspension of any action with regards to the loan in Cyprus, and this was rejected because it was unfounded. And the claim on the merits introduced, because this is a requirement when you file an interim application case, has not been progressed at this stage. And when Mr. Mays says that he did not acknowledge the default, we don't see in any of the witness statements, or even now, or in the case in Cyprus for that matter, any challenge on the default. All that we're seeing is a request for that to be offset against the deposits in Lebanon. So the default is indeed not challenged. There is default. The issue between Mr. Mays and the bank in Lebanon is whether there should be an offset, and the bank in Cyprus is whether there should be an offset. This is a separate matter, unrelated to the joinder application. That's it. Thank you.
Thank you very much. All right. Well, I propose to make a ruling now in relation to the three applications, and in due course, no doubt that can be transcribed and turned into a formal judgment. There are three applications before this court. And the first is an application by Société Générale Bank in Cyprus, dated 31 July 2023, for it to be joined to the proceedings under RDC 20.7, and for a debt which it asserts it is owed by 5 Dining Corporation Limited to be taken into account by the receiver, who has been appointed in relation to the judgment that this court entered against Mr. Manis some time ago. The second application is that of the receiver, which is a restored application, which seeks directions as to what to do with the receipts of the proceeds of sale of the restaurant business, which was owned by 5 Dining, and which in turn was owned by Mr. Manis, and to which the receiver was appointed. There is some 5.5 million euros of sale proceeds. In addition, the receiver seeks to recover his fees out of the proceeds and for an increase in the cap on those fees which I had previously ordered. Thirdly, the claimant seeks an order that the receiver distribute the balance of the sale proceeds to it following the judgment in its favour and the appointment of the receiver.
Your Honor, can I just clarify something again? I'm so sorry for interrupting. But the original application we submitted, yes, was for the receiver to take that to take our claim into consideration, but that had changed after the elements that were introduced in the parties' responses to the joinder application, where a matter unbeknown to us was that the restaurant wasn't in fact sold and the proceeds were recovered by the receiver, and that the parties now are seeking to introduce a request, an application for the release of funds and the discharge of the receiver. So our position has changed between the initial application and the current skeleton of argument, where we're seeking the suspension of the release of the funds until we are joined as parties and can submit our position. It's no longer for the receiver to take that into consideration because he sold the assets and is seeking discharge. I just wanted to clarify that. Thank you.
Don't worry, Mr. Haleb. I had that in mind and I was coming to it in due course. Dealing first with the application of the bank, which, as it turns out, is for the preservation of assets so it can pursue a claim which it has now launched in the DIFC against Five Dining in respect of monies which it says it is owed under a loan agreement. On the 3rd of October of this year, the Société Générale Bank Cyprus, to which I shall simply refer as the Cyprus Bank, instituted proceedings claiming sums of money which were said to be due under a loan agreement. Counsel for the Cyprus Bank says it doesn't matter whether or not the claim is for the total sum of the loan, which is said to have been called in following termination on default in the failure to pay interest due in September 2022. So what in essence the bank is seeking is that money should not be paid out at this stage to the claimant, because it has a claim against Five Dining Limited, whereas the proceeds of sale come from the restaurant owned by Five Dining Limited, and the judgment that has been entered already is against Mr. Manes as the owner of that company, and therefore indirectly of the restaurant business itself. The question still arises in relation to the joinder that is sought and whether or not that is a permissible or an appropriate course. The terms of RDC 20.7 are as follows. The court may order a person to be added as a new party if, 1, it is desirable to add the new party so that the court can resolve all the matters in dispute in the proceedings, or 2, there is an issue involving the new party and an existing party which is connected to the matters in dispute in the proceedings, and it is desirable to add the new party so that the court can resolve that issue. As will be apparent from what I have already said, the way that the Cyprus Bank puts its position is this. It says that it is owed money by Five Dining Limited, and therefore it has an interest in the sums of money which have been realized in order for the judgment against Mr. Manes to be satisfied. Looking at the terms of the rule, I am unable to see how the Cyprus Bank can bring itself within the terms of the rule. If one asks the question whether it is desirable to add the Cyprus Bank so that the court can resolve all matters in dispute in the proceedings, or if there is an issue involving the Cyprus Bank and Mr. Manes, which is connected to the matters in dispute in the proceedings, and it's desirable to add the new party so the court can resolve that issue, the answer in both cases must be negative. So far as matters in dispute in the proceedings are concerned, they have been resolved in my judgment against Mr. Manes. All that is in issue now is the manner in which that judgment can be enforced following the appointment of the receiver and the realization of assets which were indirectly owned by him. If it is asked whether there is an issue between Mr. Manes and the Cyprus Bank, which is connected to the matters in dispute in the proceedings, the answer must be no, there is none. It cannot be desirable, therefore, for the Cyprus Bank to be added for the resolution of any issue which remains outstanding in the proceedings as such. The key to this seems to me to be essentially very simple. Five Dining Limited is not said to be insolvent. It is not in liquidation. It has, on the evidence plainly, sums of money held on deposit, not by the Cyprus Bank, but by a related bank, which appears to be its parent bank, the Société Générale in Lebanon. What is said by the Cyprus Bank is that these two entities are separate legal entities, as indeed no doubt they are. It is also said that there is no direct collateral in relation to the loan agreement, which has been extended by the Cyprus Bank, and the sums of money held on deposit in the Lebanese bank, albeit that the sums are equivalent one to the other, and the interest earned on the one is sufficient to pay the interest on the loan from the other. It is trite law that in the absence of insolvency, where a judgment has been entered, it can be enforced regardless of the interests of other creditors. First past the post has invariably been the relevant principle. If a party is entitled to enforce its judgment by the appointment of a receiver and the realization of assets, that cannot be inhibited by the fact that there may be debts owing by the same creditor, by the same debtor, or indeed by a company owned by the debtor, until a judgment has been entered and there is some question of insolvency, whereby a liquidator must then distribute the assets of the company pari passu amongst the creditors. That is not the position here. There is an additional point, which is whether or not, in fact, the Cyprus Bank has established that there is, in any event, a sum outstanding. There is an argument which arises, which I am not able to determine at this stage, in relation to the authorization given by Mr. Manes that sums due on the loan from the Cyprus Bank should be met by payments from his assets at the Lebanese Bank. I have been referred to a letter of September the 29th, 2020, which is said to authorize payments of interest both for September 2021 and September 2022. It is accepted that payment was made by the Lebanese Bank of the interest due on the Bank of Cyprus loan in September 2021, but it is said by the Cyprus Bank that no authorization was given in relation to the September 2022 instalment of interest. That may depend upon the manner in which the letter of the 29th of September 2020 is interpreted. This has apparently been the subject of proceedings in Cyprus. The receiver, quite properly, it seems to me, took the view that there was a commercial dispute, which was the subject of proceedings in Cyprus, which appear to be dormant for the moment, as to whether or not there truly was a default on the part of Mr. Manes on the Bank of Cyprus loan. And as to whether or not that default had the effect of entitling the Cyprus Bank to call in the loan in its entirety. I'm not in any position to determine that issue, as I've already said. I do not have before me evidence of Cyprus law in relation to the effect of a default in the payment of one instalment, and the particular clause that has been relied on is not clear in its effect as to whether or not it would entitle either contractual acceleration of the loan or termination, with the result that the whole of the loan then becomes due and payable. None of that, at the end of the day, appears to me to matter very much. The ultimate position here is that 5 Dining is not assetless. There may be difficulties about accessing the assets of 5 Dining in Lebanon, or there may not. There is plenty of English authority to suggest that the Lebanese banks have imposed restrictions on themselves so far as transfer of assets abroad are concerned. But long after the crisis in Lebanon took place, it is accepted by Bank Cyprus that sums were paid to it in September 2021 by way of interest to meet the interest due on its loan to Mr. Manis. The issue arises as to whether or not that could and should have taken place in September 2022, and therefore whether there is in fact a default, and whether that would entitle the Cyprus Bank to call in the loan as a whole. Ultimately, however, for the reasons I've already given, there is no basis upon which the Cyprus Bank can be joined properly to the existing proceedings. It has commenced its own proceedings against Mr. Manis in the DIFC, which no doubt can be pursued as thought appropriate, subject to any jurisdictional or other issues there may be. But in the absence of a judgment or a proved debt on the part of the Cyprus Bank and an insolvency in a liquidation of 5 Dining, there can be no possible reason for interfering with the enforcement of the debt due to the claimant in this action, MAD Atelier, against Mr. Manis. So far, therefore, as the 3 applications are concerned, the application of bank of the Cyprus Bank must be dismissed with costs. The application of the claimant for payment out of the proceeds subject to payment of the receiver's fees should be granted. And in the absence of any objection to the receiver's fees, the receiver is entitled to an increase in accordance with the application made. Now, is there anything else I need to deal with apart from issues of costs?
One issue, Judge, what happens to the shares in 5 Dining? So
thank you very much. Yes, it's agreed that the shares should be transferred back to Mr. Manis, isn't it?
Yes, once the payment is made, once the distribution is made.
Once the payment is made, yes. It's the right thing.
I'll just interrupt. There's just one issue I'd like to consult my client on. I was wondering if it was a very short recess whenever the court is finished delivering judgment.
Yes. Is there anything else that I haven't dealt with that you think should be dealt with, or is that what you want to talk to your client about?
That's what I want to talk to my client about, Judge.
All right.
My lord, I have just a small request.
Yes.
On the skeleton of the claimant, they are requesting to transfer the full cash available in the account of FDC. Is there a way that the claimant agree to keep a small amount in order to perform the changes at the registry and be able even to to reply on the small claim done by Société Générale, because it's a small claim for declaration about 9% interest, so it's not a big claim. But if the claimant cannot keep the bank account at zero, it will be helpful to just keep a small amount, even if there is need of undertaking from Five Dining and me, in order to support even the sale just happened 1.5 months ago. If there is a supplier invoice missing, or an employee who claimed that he was not paid for something, just a small amount, I let the claimant fix it properly, but to leave the bank account at zero, it's a bit difficult to be able to proceed at all the modification, pay the rent for the office domiciliation. Thank you so much, my lord.
Well, what I'm going to do is I'm going to take a recess for Mr. Prasivka to take some instructions, and for others to consider what you've just said. I will sign out for the moment, and then when the parties are ready, no doubt the court associate can send me an email and I will rejoin. And Mr. Montague-Smith, I would then be thinking of going through the draft order that you have prepared.
Yes.
To make an appropriate order with whatever amendments may or may not be necessary.
Thank you. Yes. Very good.
All right. So we'll assume, I'm going to assume that it'll be about a 10-minute break or thereabouts, which at least will give me a chance to have a cup of coffee, if nothing else.
Very good.
All right. I'll tell you what, we'll say on the hour. All right. Come back on the hour, unless anybody needs more time, in which case they can ask for it.
Thank you.
All right. Thank you.
I'm ready to proceed. Officer.
Is everybody back and ready to proceed?
Yes, my lord.
Yes.
Very good. All right.
Thank you, Judge, for granting the short recess. I just maybe the 22nd of September, my client filed updated accounts, and
Yes.
the updated accounts give the final balance. And my client points out in the next few days, certain expenses or expenditures my client has to make the ordinary course of business. Now, I believe that Mr. Montague-Smith's draft order accounts for that. So in those circumstances, we're really seeking no further relief. I'm really happy with Mr. Montague-Smith's draft order.
I'm afraid you broke up so far as I was concerned, so I didn't get the last couple of sentences.
Sorry, Judge. In Mr. Montague-Smith's draft order, perhaps we could go to that draft order. That might be the best way of addressing this issue.
Yes, well, does this meet Mr. Manny's concern up to a point or not?
I think Mr. Manny's is a separate application. So my understanding is that essentially my client will transfer the shares to Mr. Manny's, and before that he will transfer all remaining receipts to the claimant.
Yes.
And the only issue that I wanted to flag to the court is the remaining receipts may be slightly different than the receipts listed in the accounts on the 22nd of September. And the reason for that is that my client has to make certain payments in the course of business as a receiver in the next few days.
Yes. How does that impact on the order that I make? It's simply that there'll have to be a final account, so to speak, at some point.
Exactly. That's all. That has to be a final account. And so I believe in Mr. Montague-Smith's order, he has given specific figures. And those specific figures come from the receiver's updated accounts. Now, in all fairness to Mr. Montague-Smith, he also says less any further deductions which the receiver is otherwise authorized to make. So I believe that this is, I'm reading from paragraph 2 of the draft order. So I believe that accounts for essentially what the receiver is looking for. And I would say that in the recess, we've examined the draft order and we're essentially happy with the wording. Now, if Mr. Mayonnaise has a separate application, I obviously welcome to make that now.
Very good. My lord, I wonder if it's worth going through the order, but just in relation to Mr. Manus's request, I can explain where I've got to. And the way I would put it is I haven't had a yes, and I'm not holding my breath. I think that Mr. Manus would like some money to be left so that he can defend various actions. And I think our position is, if that would be a large sum, we would say no. If it was a small sum, he can provide it. At the moment, he owes us a very large amount of money, which some of which will be dispensed with by this. So I haven't had a yes. I don't have firm instructions either way. But as I say, I'm not currently holding my breath.
Yes, well, I mean, on the face of it, you've got a judgment that you're entitled to enforce. And so anything that is left behind is an indulgence to Mr. Manus. So I think the appropriate thing is that I make an order in the terms that are sought. And if there's an element of generosity on your part in leaving money there or whatever, so be it.
Very good. All right.
Let's go through the order then.
Thank you. The order is at page 1486.
Right. I think I printed off a hard copy.
Oh, very good.
It may be different, of course.
No, if it's the same one that came with our skeleton argument, then it's the right one. That's all. It's just been added to the back of the bundle. And I think the best place to start is 1487, or the second page of the order. And I won't take you through the recitals unless you'd like me to, but paragraph 1 simply recites the increase in the permitted fees and expenses of the receiver. As your lordship has noted, there's no objection to that. And then my learned friend has already referred to paragraph 2, which is simply the distribution of the receipts. And as my learned friend points out, it is less any further direct deductions which the receiver is otherwise authorised to make. There are no points of principle between the parties and the receiver as to any further sums. It was simply this alleged loan amount. So I do not consider that will lead to any difficulties. In terms of the mechanics, that is dealt with in paragraph 3. And
before you go there, Mr. Mosky-Smith, otherwise authorised by whom?
That they are otherwise authorised to make as the director of, in his position as the director of the company. So he's entitled to perform the remaining bits of his mission. The distinct
under the existing authority given him by the court. Yeah,
exactly.
Yes.
Exactly.
That's all we're seeking.
So if you're happy with that, then there's just a short passage about the mechanics. We will provide the identification of the account. I would imagine the receiver would rather pay the monies in the currencies in which they are, but we can discuss that if that is different. So we will try to provide 3 accounts in 3 different. If we cannot, then we will discuss that with the receiver. And then after that, paragraph 4, it is the mechanics for termination of the receivership. Paragraph 4.1 should probably say, after the distribution, transfer of the shares in 5 Dining, not the share capital, but we can amend that if needs be. And then she'll retire as director. Yes. And then paragraph 5 is discharge. And paragraph 6 is simply the obligation on 5 Dining to assist. Your lordship has already identified the answer to paragraph 7, which is as drafted, which is that the joinder application is dismissed, and then it's simply costs.
Yes.
So unless there are any points that anyone else would like to make in relation to the terms of that order, and hopefully Mr. Pacific has already stated that they're happy with it, I was going to go on and deal with costs.
Yes, all right.
Very good. Costs you will find at the back of the bundle, I believe now. I have them in PDF copy.
I think I've been sent them separately, I think. Well, it doesn't matter if they're at the back of the bundle, give me the reference.
It'll be the final page. I'm sorry, I need to update the bundle. I think they were only added to the bundle very shortly very recently. So
Well, don't worry, I'll get. I've got an email somewhere.
very good. If you have them independently, then that will be helpful. They start at page 1490 if you still have the bundle. Otherwise, if you have them in email, then that's equally useful. There are two cost schedules. One is for the joinder application. One is for.
Hold on, Mr. Montague Smith. I'm afraid I'm not with you. Right. I seem to have. I've got two cost schedules here.
Very good. The ones in the bundle are in relation to the.
Go on. I'm looking at them separately because my bundle doesn't go beyond 1487 at present.
I'm sorry. If you press refresh on your browser, you may find that it updates because they were recently added. I had to do the same.
Okay, hold on. Silly question. Where am I going to find refresh?
It depends which browser you're using, but it should be the top left next to the back button, right on the banner, next to the URL line where you put in the numbers and the address. If you right click on the screen, it should be one of the options that comes up on the. It's a little circular arrow.
You can also click on F5 on your keyboard, Sir Jeremy.
Thank you.
Let's see if I've got anything now. I'm having trouble there, but I've got a cost schedule. NRF's cost schedules for receivership costs is one of the things I've got.
Yes.
With a figure of $150,000.
Yes. So that will be for the receivership. I was going to come on to those latterly, right, because I think those probably need to go off for detailed assessment, albeit you may be happy to make a payment on account, order a payment on account in relation to them. You should also have a schedule of costs for SocGen's joinder application.
Got that, yes.
That consists of two schedules. One is relation to NRF, Norton Rose Fulbright. The other one is Mishcon de Reya, which is the London firm who were dealing, as you may recall, with the London litigation, and so they are remain involved in the case. The totals for the joinder application you will see at the bottom of the first page 1490 on the bundle, for if you ever do get access, which is 53,657 and 10, and then you've got an English pounds total for Mishcon de Reya of 33,225 and 25 pence. So I just make the points that the partner rates and so on are, I think, within the guidelines set by the DIFC court, in fact, well within, and it's difficult always to give you an awful lot of guidance on the amount of time that's been undertaken, but the largest parts of it, I suppose, you will see are relating to the work on documents section as ever, and then in relation to brief fees, those are identified as £9,000, and that is a proportion of the fees, 1/3 of the fees that were referable to this hearing. Initially, the hearing was going to be undertaken by Mr. Watson. Unfortunately, he fell ill and remains ill, and I had to step in to pick it up. But we have made sure that the total that we have charged is less than the total I would have charged for the hearing had I been instructed from the beginning. So there is no overlap to that extent. So unless you have any specific questions on that cost schedule, we'd ask for those sums. Really, without much deduction, we say that they are eminently reasonable, but we would.
Well, I'll hear what anybody else has to say about it in a second, but I hope Mr. Watson is not seriously incapacitated.
Well, it is a serious illness, sadly, but he is recovering, and we hope and we are confident he will make a full recovery, but it may take some time.
Well, I'm sorry to hear that, and without wishing to intrude, the court would send its best wishes.
I'm very grateful, and I'll pass those on. Thank you.
Yes, now, does anybody else want to say anything about these costs?
No, Judge, the receiver is no position. It's between the claimant and the SocGen.
Sorry, I didn't hear the receiver's counsel's comments.
Sorry, the receiver has no position on the costs application. The cost application is claimant and Societe Generale.
Yeah. So if there's anything you want to say about the reasonableness or unreasonableness of these costs that are being claimed against you, Mr. Halib, now is the time to do so.
Yeah. With regards to that, Your Honor, the amount of work that has been put into this, or the claimant claims that has been put into this, we have seen a skeleton of argument that is 10 to 15 pages long, and no further documents drafted for that, except another witness statement presented in advance in response to the joinder application, and a brief skeleton of argument reiterating the same previous position for that. So for the joinder application itself, to indicate that the London office at the same time was involved in the litigation to address the joinder application itself, and those excessive costs that the claimant indicates have been accounted for this litigation, we do obviously object to that. We don't see the justification for this amount of work that has been put into that. So we do not believe the amount of costs being claimed is reasonable for this joinder application. I believe the claimant is including into that the preparation for the hearing that involves an application by the applicant itself and an application from the receiver. But in terms of the joint application itself, we do not believe it's reasonable to have incurred that amount of cost, particularly the side of the English law firm.
But the two things there, Mr. Khalid. Are you objecting to the London costs specifically?
Indeed.
You are, yes.
Part of that, yes.
Yes. As I understand it, there's another schedule of costs that relates to the other applications as opposed to your application. So it may be necessary to look at both of those in the round. Let's just look at the other schedule of costs, Mr. Montague-Smith.
Certainly, yes. That is not Rose's schedule of costs for the receivership and dealing with it as a whole. So the way I would put it is that the need for this hearing has been driven by the bank's intervention.
That's true.
And on that basis, yes, we would have had to make an application to your lordship to release the funds. Yes, the receiver would have had to make an application to come off, but we probably could have dealt with all of that on paper had the bank not sought to get involved. On that basis, in my submission, seeking 56,000 and 33,000 pounds, $56,000 and 33,000 pounds is by no means excessive, and it probably comes in at under 100,000 US dollars for a hearing of this sort. That is, in my submission, totally reasonable. The rest of the costs relate to the other aspects of the receivership, and so the formal requirements to make applications beyond dealing with the bank's application. But that will be a matter for detailed assessment. If your lordship is happy, we would ask for a payment on account of those costs. That will be a matter between us and Mr. Maness, because it should be for Mr. Maness's account to pay for those costs ultimately. But you can deal with those in a much more broad brush way.
What do you say about the need for London involvement at all? I mean, I asked the question, why would London need to be involved in dealing with the joinder application?
Well, they were sorry,
£33,000.
Yes. So it's a question of separating out all of the tasks that needed to be undertaken. It's not a question simply of duplication. They are the client in the sense that they have the instructions from the end client, and also would need to deal with the issues, the substantive issues that were raised by the bank, which go beyond sort of technical questions of whether or not this comes within Part 20.7, because all of the factual allegations that were being raised were raised by the bank in that context. So it's not really a question of saying, is it 56,000 is the cost? Is it okay to add on another £30,000? It's saying in the round, these are the people who've done all that work. Is that a reasonable total? So had they not been involved, put it that way, you wouldn't have got anywhere near getting this application off the ground and dealt with for 56,000 US dollars. So it's not fair just to say you can't layer on London, because it's all part of the work that's been done to meet these applications.
All right. Well, usual broad brush approach, I'm afraid. I'm going to say $40,000 in respect of the UAE end, and £20,000 in respect of the English end.
Thank you. Understood. Very good. All right. And then in relation to the cost of the receivership, the principal question is whether or not those should be paid by the first defendant. We say they should for obvious reasons, and I don't need to take you through those. I don't think that we've heard from Mr. Maness on that, but you may want to hear from him. In relation to the numbers, again, we have two schedules, and sorry, I'm struggling a little bit myself with the technology, but there we go. They appear at page 1493, but I think you've got them separately. As I mentioned, you have a total of 150,000 US dollars and 611. That's Norton Rose, and then 85,000 pounds 690, and that is costs of the receivership as a whole, as I understand it. So what I'd be seeking from you today, my lord, is something like, well, the starting point, the rule of thumb is 50%, but if you were feeling generous, we would ask for 60%, which would come out at around 90,000 US dollars and 51,000 pounds.
And this is start to finish.
I believe that is right, unless somebody's going to tell me no. I believe that is right. Yeah, start to finish. That is start to finish. So there is in the background an international. I should have said there's an international effort to recover these sums, which goes beyond this court, goes beyond London, and that is also the need. Explains the need for Mishcon de Re's involvement, because they are coordinating that as a whole.
This is the flat in Paris and that sort of thing.
And the proceedings in Belgium as well. So,
I forgot,
so there's more than just this jurisdiction involved. So in relation to that, it is potentially quite significant that we get at least some crystallized costs order, because as the money comes across, it'll net off. We say it should net off first the costs. rather than reducing the value of the English judgment debt that's outstanding, which can then be enforced elsewhere. Otherwise, we'll be left with an unsatisfied judgment in various different places rather than a single one, which is finally being chiselled away.
Yeah. So remind me again the figures you're asking if you on the basis
on account. Yeah.
Generous.
On account, 60%. Well, it's not that generous, but 60% would be $90,000 and £51,000.
Yes. Mr. Manis, as you're the person who is going to ultimately be liable for this, do you want to say anything about those figures?
I think what I do think is that I should pay the cost of Norton Rose, but if the court is granting also the cost of Mishcon, I follow the rules of the court for sure. The only thing that I believe it's important is that we have a last order that you ordered in February 2023 for $800,000 approximately, representing the cost of the claimant. I believe that this judgment is satisfied by the effect of the payment of today. Am I correct?
I can't tell you that. I don't know.
Ah, okay. And how I can know if there is and for the main judgment, there is €3 million of cost at 8% on the judgment enforced in October 2022. How the payment of today is depreciate the total amount due to the claimant?
Well, I think what I'm going to do, Mr. Manis, is ask the claimant to write to you following the payments which are being made here to let you know exactly what the overall position is. In other words, what's been paid off and what hasn't. All right, so you know where you are.
Thank you, sir. Thank you, my lord. Thank you.
All right, Mr. Montague-Smith, you can have the figures that you've asked for on a 60% basis.
Thank you very much, my lord.
As a payment on account and the rest to fall for assessment.
Thank you. Very good.
All right, does that conclude the business for today?
From my end,
Yes.
yes, my lord.
From the jury's perspective, yes.
Yes.
All right, very good. Well, if you would produce a form of order, Mr. Montague-Smith, for agreement with the other parties and submit it to the registry, then I can approve it as necessary.
Thank you very much, my lord.
All right, well, if you wouldn't all mind signing out, then I'll have a word with the associate.